It is 10 a.m. on Thursday, October 21st, 2021, and we are going to start the Orthotists and Prosthetists Advisory Board meeting as of now. So for the first, after calling this to order, I want to remind everybody to keep their microphones on mute and turn them on when you speak. And please announce your name before you say something each time you want to speak. We will go ahead and move forward with a roll call and certification of the quorum. Anna?
I will be doing the roll call for you.
Okay.
Miguel Mojica is absent. David Arends.
Here.
Randall Duncan.
Here.
Mark Kirchner.
Here.
Ray Smith is absent. And presiding officer Catherine Mize.
Here.
We have a quorum, ma'am.
Thank you. All right, we're going to move on quickly to the training for the advisory board members. This happens, I believe, once a year. So I'm going to introduce Alex Phipps, who is our Assistant General Counsel, and he's going to take us through this quick training program.
Good morning, advisory board members. I'm here to present the training. I'm going to share my screen right now to give you a PowerPoint that we prepared in the General Counsel's division covering all the topics that we need to go over today. Please let me know if you have any problems seeing the PowerPoint. And I'm going to walk through it pretty quickly, but of course, if you have any questions, please feel free to stop me and ask. And we're always happy to talk to you after the training, after the meeting, if you have any questions at all. So with that said, I'm going to get started and we will go through the training. So obviously this is the advisory board training. I am Alex Phipps. I'm the Assistant General Counsel assigned to this program. If you have any questions at all, feel free to contact me. So the overview for today is we're going to talk about the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. And these are the three primary legal controls that act upon an open meeting like this advisory board meeting, and the actions of the agency when we are entering into rulemaking or engaging in any other regulatory act that the Texas legislature has empowered us to do. So going through these, we're going to start with the Open Meetings Act. The purpose of the Open Meetings Act, obviously, is to ensure open and transparent government. It requires meetings of governmental bodies to be open to the public and preceded by public notice of the time, place, and subject matter of the meeting. And the provisions of the Act are mandatory and are liberally construed in favor of open government. And this just means that a court will look always to ensure that government is open and accessible to its constituents. So that's something to keep in mind whenever you're looking at the provisions of the Open Meetings Act. Key concepts: quorum is the first and one of the most important. A quorum is a majority of the members of the advisory board or committee as fixed by the statute or rule that creates that advisory board. Obviously, we have 7 advisory board members, so a quorum is 4 in this advisory board. A quorum of a governmental body, including any advisory board or committee, must meet in order to take an official action. You must hold a meeting. If you have less than a quorum at that meeting, you cannot take an official action. You must have 4 for this advisory board if you'd like to take an official action. Second concept is deliberation. We also use the term discussion frequently for this issue. It's a verbal or a written exchange among a quorum of a governmental body or between a quorum of the governmental body and any other person. And that's concerning an issue within the jurisdiction of the advisory board, the committee, or whatever governmental body we're discussing. The third concept we're going to talk about is meetings. A meeting occurs anytime a quorum of a governmental body engages in deliberation regarding the public business or public policy over which the body has supervision or any kind of control, or anytime the body takes any formal action or purports to take a formal action. And then finally, we're going to talk about notice. So the Open Meetings Act requires advance written notice of the date, time, place, and the subject of each meeting that's being held. We do that here at the department by preparing the agenda. We file that agenda with the Secretary of State at least 7 days before the meeting occurs. We also put that up on our website. You can find that in the appropriate advisory board section for each program. And the board or committee cannot engage in discussions about a subject that's not included in the agenda, and that's an important thing to keep in mind. We'll talk a little more about that here in a minute. So one question we get a lot is, what about social functions, workshops, continuing education, things like that? So you keep in mind that a meeting occurs whenever you have a quorum of the governmental body engaging in discussion about an issue within your jurisdiction. How can we ever be in the same setting? Well, of course, you're free to engage in normal conversation between yourselves. You know, if you are working with someone who's on this advisory board, you have friends that work on the advisory board, you know, someone on the advisory board is your neighbor. You are welcome to speak to them about any topic that is not subject to the supervision or control of this advisory board. If you reach a quorum and you're discussing those issues, then you are possibly violating the Open Meetings Act. So again, keep it friendly, keep it discussions about, you know, what's for lunch, things like that, but do not discuss official business outside the setting of an open meeting. The key points to remember: be aware of any situation occurring outside of a properly noticed meeting. Don't engage in substantive conversations. And please beware of the walking quorum. A walking quorum occurs when fewer than a quorum of members engage in a discussion about the official business of the advisory board, but they then communicate those discussions to other members. When you have fewer than a quorum of members participating in any communication, you can quickly reach a quorum by subsequent communication, and that can still represent a violation of the Open Meetings Act. We've got an example here. We have a 7-member advisory board, just like the Orthotists and Prosthetists advisory board. 3 members engage phone calls, emails, other discussions about an upcoming rule change. And then they exchange that information with each other, the research they've done, and that's just 3 people. However, one of the board members subsequently forwards the exchange to another member. They've now engaged in a walking quorum by having the small group discussion reach all 4 of the members that are required to be a quorum. So this is a very important concept to keep in mind, and one reason why you may want to avoid discussing any of these topics even in a smaller group than a quorum. So these can happen in many different places: conference calls, video conferences. The classic example is in the hallway, going to get coffee, or outside of the restroom, stopping and having a conversation that may reach a quorum through various people stopping and having chat. And a new issue that's coming up here more frequently as technology evolves: emails, text messages, other new technologies, you know, Twitter, Facebook, TikTok, any piece of, you know, social media that you may be using, you can easily reach a quorum through those kinds of communications. So we'll give you some best practices. If you, you know, are engaging in any small group meetings, make sure you do not discuss any business outside the settings of something that we've set up here at the department for you. Don't send emails or text messages to a quorum of the members, of course, even if you're sending those individually. Make sure you don't create any posts on social media about board business. And, you know, do not ask any quorum of members. Don't do it on your own. Don't do it through anyone at the department. Conducting this is called polling. So if you go through and you ask multiple members, even if you do it individually, you can reach a walking quorum very quickly. So please avoid that as well. We have some guidelines for open sessions here at meetings as well. A board or committee is limited to discussing the specific items that are on the agenda, and that's the agenda that we mentioned previously that we prepare and post on the Secretary of State's website and on our own website here at the department. During the public comment portion of the meeting, members of the public can speak on pretty much anything they'd like to speak on. We can set reasonable limits on what they're speaking on, but they may bring up topics that are not on the agenda, that are not germane to the agenda items or the rulemaking or whatever we're engaging in that meeting. We need to make sure we don't engage in that discussion beyond the simple proposal of putting that on the agenda at a future meeting. Any substantive discussion or official action on an item that's not on the agenda could be a violation of the Open Meetings Act. We've got some guidelines here for this as well. Just limit your discussions to specific agenda items contained in the posting. Avoid allowing discussions to wander off topic or go into new areas that have not been noticed to the public. Make sure you do not respond to or discuss issues that are raised during public comment, because again, the public commenter may bring up things far afield of what's posted on the agenda. And make sure you identify items for future agendas and communicate those to TDLR staff. And we do have an agenda item for that very purpose. So feel free to bring that up at that time, but understand that you should not be discussing substantive changes or attempting to take official action if it's not on the agenda. So we'll talk about some of the penalties that happen if you violate the Open Meetings Act. First, there are civil remedies for violations. So that means a non-criminal charge. An interested person can petition the court to stop actions taken in violation of the Open Meetings Act. It means if we make a rule or we do any other kind of official action and it's a violation of the Open Meetings Act, that could be stopped, could be reversed, it could be overturned, whatever term you'd like to use. But it could be halted because of your violation of the Open Meetings Act. And anything that's voided like that will need to come back and be acted on again in the proper way. Next, we've got the criminal penalties, which are the much more important things for individual advisory board members. If you knowingly participate in a walking quorum, you can be subject to a fine of up to $500, confinement in the county jail, or both. So that there are real criminal penalties to violating the Open Meetings Act. And that's something that you need to keep in mind every time you engage in meetings or any action for the advisory board. So best practices, again, avoid communications that involve a quorum of the members, especially outside of any kind of officially noticed meeting. And during the open meetings, please confine your discussions to items specifically posted on the agenda. We have some links here. I know that you're probably not going to be able to write these down very quickly, but I'm happy to share them with you. If you do have any questions at all, reach out to us in the GC's office, and we'll be happy to walk you through these. Next, I'm going to go through the Administrative Procedure Act. So the Administrative Procedure Act governs all Texas state agencies, and it covers a lot of different topics, minimum standards for practice and procedure in front of those agencies. And it also outlines the public participation and transparency for the rulemaking process. For us, the rulemaking process is going to be the more important topic today. And the APA has a broad definition of what a rule is. It's anything that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. TDLR is a state agency, so this covers us. The rule doesn't include things that only cover the internal management or organization of a state agency. So for example, our HR manual here at TDLR is not a rule, but a rule is a new rule, an amendment to an existing rule, or the repeal of an existing rule. So basically anything you do to an existing rule will count as a rule for the purposes of the APA. There are lots of sources for rulemaking: legislative changes, obviously advisory boards, TDLR staff, 4-year rule review, which we'll talk a little more about here in the future, and rule petitions. In particular, rule petitions are a petition from an interested person. And so that interested person must be a Texas resident, a business entity in Texas, a governmental subdivision of Texas, or a public or private organization that is not an agency but is located in Texas. And that petition has to be filed as the APA prescribes. So when that's filed with the agency, we have to take action on it in the way that the APA prescribes. The important thing to keep in mind here is that you must be a Texas resident entity or other division of Texas, and that's an important qualifier for who can file these rule petitions. Now we have a very large chart about the Administrative Procedure Act rulemaking process. I'll move through this quickly, but again, if you have any questions, just let me know. I'm happy to discuss it with you. The rulemaking process starts with the idea and the drafting, and the internal review and analysis is performed, and then the review by the governor's office is also performed, and all that happens before the first advisory board meeting. You'll see that the green colors are generally things occurring at the department, and the blue colors are the public meetings of the advisory board. So obviously we are here at the first advisory board meeting. We do have rulemaking today, so we'll get to see this in action. After the advisory board meeting, proposed rules are filed and published in the Texas Register. The Administrative Procedure Act requires a 30-day comment period, and that's to allow the public to make comments, ask questions, interact with the governmental agency to make sure that they are able to express their concerns about any rulemaking. The agency will review those public comments. We will bring those back to a second advisory board meeting if they require advisory board input. After that input, the rules will be proposed and adopted at a commission meeting. And the commission is the Texas Commission of Licensing and Regulation. That's the governing body of TDLR. After that, they're adopted, they're filed and published in the Texas Register, and then they are effective on the date that they are prescribed to be effective in that notice. We also have a chart about the rule review process. This happens on a 4-year schedule. The APA requires that of all Texas state agencies, not just TDLR. We publish a notice of intent to review the rule chapter. The public has 30 days again to express any concerns or questions they have about the chapter. The GC division here reviews the comments. We make a recommendation to the commission about whether or not these rules need to be readopted. The commission reviews those filings. They generally vote to readopt the rules section because, again, this rule review process is whether or not the rules need to continue in force, or if the need for those rules has passed, then they should be repealed. Generally, they're going to feel that the rules need to continue in place. However, if there are issues that are identified either by staff or by the public, then the advisory board will be presented with comments and changes that are recommended by staff or the public, and that will be pursued through a normal rulemaking process, and that's what we're doing today. Here are some resources. Again, I know you're not going to write these down, but if you do want to walk through any of these, I am happy to walk you through them or share any of this information with you after the meeting, so feel free to ask. And now we're going to talk about the Public Information Act. So this is also known as the Open Records Act. At the federal level, you may hear FOIA. This is the Texas level of the open records concept. So this applies to all information generated by the government, official acts of public officials and employees. And the default setting on this act is that all documents, records, and other information is open to the public. And then from there, certain exceptions apply to protect sensitive personal information and other information that the legislature feels should not be shared with the public directly. But it is a very expansive definition of information. It includes any electronic communications. It can be on any device, not just an official TDLR or agency computer. And it's construed liberally, just like the Open Meetings Act, to ensure that the public has access to their governmental actions. So here at the agency, we receive generally the open records request, and we have a division of the GC, or a group in the GC division that works on the open records request. And so if you receive any requests, or if you receive any correspondence that may seem to be an open records request, please send that to us as soon as possible. There is a very short deadline for the agency to respond or to request an opinion. And as you can see, we respond within 10 business days, which is a very tight turnaround for large requests for information. So we need to know if you do receive that correspondence, or if you have anything that might purport to be an open records request. And just to be clear, we cannot ask why someone wants these records. We can only ask for clarifications about what they're asking for. The public has a right to request anything they would like to see, and we will process all of those requests accordingly. So there are, as I said, a lot of exceptions, but the presumption starts with openness. Certain information, of course, is redacted: your date of birth, certain email addresses, educational documents, of course, anything that's subject to HIPAA or the Texas Medical Records Privacy Act, that's going to be redacted or removed from the response to the open records request. And of course, the agency takes that very seriously and ensures that there is no sensitive information released. And we do have a lot of resources on this as well. This is something that, a lot of people have questions about. So if you do have any questions about a request, any questions about what may be released to the public or maybe within the scope of this act, please feel free to reach out to me or anyone else in the GC division. We'll be happy to help you with that. That said, I think we are done with the training, but if you have any questions, feel free to let me know, and I will be happy to help.
Thank you very much, Alex. Appreciate that. All right, we're going to move on to our next item, which is D, and that's the advisory board member training. And Anna Clark is going to do that for us.
Thank you so much for being here, everybody. I am Anna Clark. I'm the program specialist for this advisory board. And this is our first meeting via video conference. The public is watching via YouTube Live, and it is being recorded. It will be available on TDLR's YouTube channel after the meeting. Here are some tips to make sure we have a successful meeting. Please mute your mics unless it's your turn to speak. Silence all cell phones and other sources of noise in your workspace. Please refrain from moving as fidgeting draws attention away from what's being presented. Raise your hand, excuse me, if you wish to speak, and the presiding officer will call on you. State your name before you begin speaking. If you have issues connecting during the meeting, please let the presiding officer know. We also have staff working in the background that can assist you. Please stay on camera at all times, even if you're not speaking. If you need a recess, you may let the presiding officer know by raising your hand visibly on the camera and saying your name. If you get disconnected, please rejoin using the same link you used to join at the beginning of the meeting. We will do roll call votes during the meeting for all necessary items. I will call on each board member individually. You'll unmute your mic, give me your vote, and then mute your mic again. We've conducted several of these meetings, and using this medium, we have had a few minor blimps, and that's okay. We'll take care of it in real time, taking a recess if necessary, and we'll get through each of our items on the agenda. Thank you everyone for participating. We appreciate you taking the time out of your day to be here. Presiding officer. You're muted, ma'am.
There you go. So thank you, Anna. Moving on to item E, where it is the approval of our minutes from our last meeting, which occurred on January 13th of 2020. So that was sent to everyone in their board packet. Did everyone have a chance to go over those minutes?
Yes, and the motion to approve.
Do I have, so Randy was the initial motion. Do I have a second?
Second.
Thank you, David. And so now we go to a roll call vote on it.
Yes. David Arends.
Yes. Aye.
Randall Duncan.
Yay.
Mark Kirchner.
Aye.
And presiding officer Catherine Mice.
Aye.
Motion passes, ma'am.
Thank you very much. All right. Next item on the agenda is F, public comment, and we did not receive any public comment. So we will move on from there. Next, we go into item G, which is staff reports, and we're going to hear from a person from TDLR that represents each one of these individually. And we will start with the licensing division and hear from Leonard Rivas.
All right. Good morning, advisory board members. My name is Leonard Rivas. I'm with the licensing division, and I'll be going over the numbers for the Orthotists and Prosthetists program. And so you have a copy of the report in front of you, and I will briefly go over the different license types for orthotists and prosthetists for fiscal year 2021. Licensed prosthetist, orthotist, new licenses for 2021, we issued 21. We renewed 153. The total population for that license type is 317. Licensed prosthetists, we issued 9 new licenses, 52 renewals, and the total population is 92. Licensed orthotist, 5 new licenses, 70 renewals, and the population is 107. Registered prosthetists, orthotists students, we issued 31 new licenses, 2 renewals, and 62 is the total population. Registered prosthetist students, 5 new licenses, 0 renewals, and the total population is 16. Registered orthotist student, 6 new licenses, 1 renewal, 16 is the population. We did not issue any temporaries for FY 2021. So moving on to licensed prosthetist orthotist assistants, we issued 6 new licenses, 10 renewals, and the population is 26. Licensed prosthetist assistant, 1 new license, 4 renewals, the population is 11. Licensed orthotist assistant, 2 new licenses, 11 renewals, and the total population is 25. Accredited prosthetist orthotist facilities, new licenses issued 34, renewals 88, and the current population in 2021 is 213. Accredited prosthetist facilities, 3 new, 14 renewals, the population is 32. Accredited orthotist, oh, go ahead, Catherine. Sorry.
Finish that last one and then I'll
Okay.
ask. Sorry.
Sure. Accredited orthotic facilities, 1 new license, 10 renewals, and the current population is 16. And go ahead.
Could you remind everyone what the fiscal year term is?
Sure. So the fiscal year term, we just started FY 2022. So it starts 9/1/2021 through August 31st, 2022.
All
And we
right.
did not have numbers for September 2022 at the time of this report.
Okay. And if I could ask, Leonard, how are you all doing the accredited facility new licenses? Are you doing live inspections now and going to the facilities, given the current?
That's a great question, Catherine, and that's going to be a question for our field inspections division when they give their report.
Okay, thank you.
Okay. And the last thing I have is we did not have a in-person or video work group for the licensing work group. Our GC, Alex Phipps, did send an email with proposed rules to the advisory board members on the licensing work group. And that email was sent out on September 28th regarding licensing standards and other cleanup language. And Alex will be presenting that later on in our meeting. And I will be happy to answer any other questions if you have any.
All right, everyone's good? Thank you very much, Leonard. So I
You
guess
are welcome.
we move to the next one, which is the customer service division, and we're going to hear from Dawn Robinson on this area.
Good morning, advisory board members and TDLR staff. Please excuse the sun. It just happened to come right in my window just as I get on camera. So excuse me. I am Dawn Robinson. I'm one of the managers here in customer service. We have a few personnel updates and statistics for you today. After 15 years of service, our wonderful director, Trey Seals, has moved on to pursue other endeavors. We have a new customer service director. His name is Tuan Nguyen. And when I say new, he has been here with TDLR for 7 years in the customer service division, and he has moved up to our director position. We're also here in customer service excited to announce that we have hired 7 new customer service representatives. So our customers will be hearing some new voices in the next month or so. They started October the 1st, and they should be on the phones around the 1st of November. We also hired 1 new quality training analyst. He has been with customer service for several years. He has moved up, and he is now one of our quality training analysts. For our statistics today, our emails, we are actually down. FY21 emails are down from 2020, from 424 to 179. And the actual calls are up from 735 to 872. over fiscal year 20 to 2021. I'm here if you have any more questions for me.
Does anybody have any questions? Okay, so Dawn, I have one.
Yes.
When you all hire, you said you hired 7 new customer service folks to answer the phone. How are they trained in, given how many, you all have so many programs now that you handle and that you cover as TDLR. How are they trained in each one of the specific programs to answer questions effectively?
So our main training is the main bulk of our training is navigation through the website, because most of the information is on the website, and we try to teach them how to actually navigate. We actually have a call workflow which tells that CSR to what to do between steps A and B. We train on frequently asked questions. We try to give training on some of the licensing processes and how the actual licensing works. So we have quite a few ways of training, and we are hoping to institute specialization, which will kind of make it a little easier for our CSRs. We're currently working on that. So in specialization, we have certain groups of the CSR of the customer service, and they will manage and take phone calls for certain license types. So it will be much easier. Right now, some of our CSRs are finding it a little more difficult with handling all the license types at one time. So we're hoping to institute specialization that's coming real soon, and we think that'll make it a little easier for our CSRs to answer certain questions.
Great. And is that, you said real soon, sometime over the next year, perhaps?
Actually, we're hoping to institute that before the end of the year.
Oh, good. Okay.
So we're gathering information and trying to get the process started. So we're hoping to have that up and going in the next couple of months.
All right. And I just would like to offer up, as you create that specialization, if you need anybody from the board to visit with that group of people that are answering phone calls, to maybe give them a little bit of insight into our profession, to help them navigate questions and answers, I'm sure several people on our board would be happy to help out with that.
Thank you. Thank you. We'll take that into consideration. We can do that. Thank you.
Thank you. All right, so we will now move on to Enforcement Division, and Chris Funderburg is going to do this presentation for us.
Thank you, Madam Chair, Advisory Board members. My name is Chris Funderburg, and I'm here today to present to you the Enforcement Division staff report and to attempt to answer any questions about this report the board might have. The first section of our report summarizes notable personnel changes in the Enforcement Division that have occurred since this board last met. And as that meeting was held almost 2 years ago, you might guess that the list of interim changes is now fairly extensive. While each of these current and former employees of the department deserve individual recognition for their accomplishments, there are more effective and less cruel ways to do so than simply reading the entire list at you. Instead, I'd like to go over a few highlights and leave most of it for your review. First, the most dramatic update has to be Ron Foster's promotion from lead enforcement prosecutor to the director of enforcement, with Mr. Foster taking over this position from Christina Kaiser after she too was promoted to this time to the deputy executive director of the Regulatory Services Division. Another seismic change was the retirement of investigations manager Greg Dodson after 22 years of service with TDLR. His position is now filled by Arthur Arvelo, a former police officer who has served with the Austin Police Department for nearly 26 years, and since his hire has proven to be a replacement worthy of Greg. Other notable changes include former senior prosecutor John Medlock's promotion from senior prosecutor to chief prosecutor, and Karen Cox and Trevor Thielen's promotions into their new roles as senior prosecutors. To fill these vacancies, Amanda Barrera, Arusa Nizami, and Natalie Olvera were promoted from within the department to fill those Attorney 3 positions, and now 3 newly hired attorneys occupy those positions of Attorney 2, Sarah McKinney, Rachel Sashan, and Hunter McKinley. Finally, in August 2021, Cynthia Marple joined enforcement after serving with the Department of Public Safety in their Regulatory Counsel Division. That concludes our personal updates, and with that, I'll turn to the second section of the report. This section focuses on statistics that we've distilled from data generated by enforcement's case resolution process, as I'll explain. But first, please note we've attempted to provide a broader perspective of our efforts by including stats generated during the past 2 fiscal years. The first set of statistics is drawn from fiscal year 2021, which, as was discussed earlier, began September 2020 and ended August 2021. The next set of statistics is actually fiscal year 2020, which began September 19th. Began in September 2019 and ended August 2020. So I'll start with the section key statistics. These performance measures are particularly important as the data that they summarize is the data used by the Texas legislature to assess the effectiveness of the department's regulatory efforts. First, you'll notice that orthotists and prosthetists, excuse me, I've been trying to pronounce that all day, cases comprise about 1% of all enforcement cases opened since September 1st, 2020. Digging a little deeper, we can see that at the start of fiscal year 2020, there were 7 enforcement cases open. Over the next 12 months, 9 more were open for a total of 16 cases opened in 2020. Of these 16 cases, in 2020, we resolved 11 of them, a total reduction of about 70%. Closing more cases than we opened is a crucial performance measurement, and as you can see that in 2020, we achieved it handily. Next, well, as you'll notice, the time required to resolve these cases is higher than average. I think this is likely due to the frequently technically complex allegations in this profession, and also the need for expert advice to assess the allegations' viability. One very reasonable question, also I believe the extra time spent working these cases would explain the higher percentage of cases that actually result in disciplinary action in this profession. One very reasonable question you might have right now is, what's a disciplinary action? So now is probably as good a time as any to define that term and some of the other terms you'll see on the next few pages. So all of these terms are derived from enforcement's case resolution process, which starts when the department receives a complaint that alleges a law or rule we regulate was violated. Depending on who filed the complaint, excuse me, it will go into one of 2 categories. If the department files the complaint due to concerns about the criminal history of an applicant for a new license or to renew an existing one, then that case is characterized as a criminal history case and assigned to our criminal history team to determine if we should issue a new license, renew an existing one, or deny the application and revoke the existing license. Now, the next category of cases, the only other category of cases, is everything that's not a criminal history case. And these are given to the attorneys assigned to a particular program wherever that complaint was filed. Both types of cases end in one of 2 ways, with some type of disciplinary action taken against the respondent or without such action. A case that results in disciplinary action when a final case pleading is affirmed via the signature of either the departmental commission or alternatively by our executive director. Disciplinary action may take the form of default order, which is when we allege violation committed by a respondent, send them the appropriate pleadings, they don't respond, the pleadings are taken as fact, and we proceed on a default basis. An agreed order, which is the result of a negotiation between the parties, hence the agreement, and through litigation, which is typically heard at the State Office of Administrative Hearings. So if a case ends without disciplinary action, it is classified as informally resolved. And this informal resolution can take one of several forms. For example, when a case is dismissed for lack of evidence, that's informally resolved. When for reasons of policy or equity, we're not going to seek a penalty, instead issue a warning. Also, dismissal for inadequate jurisdiction is an informal resolution, etc. So I realize that was a detour, but I hope this sets the rest of the statistics into some sort of context. If you'll take a look at page 3 on the top, you'll see that the sources of the bottom of page 2, the sources of cases open for fiscal year 2021. The pie chart represents the sources of complaints that I was referring to earlier. Here, 33% came from the department, 45% can say from consumer-driven complaints, and 22% from department's own review of criminal histories. This is approximately the same breakdown that we see in the TDLR as a whole. And now if we could, moving on to page 4. Thank you. As you'll see, the terms that I was referring to earlier now appear in this case outcome section. We had 0 commission orders, 0 default orders, 3 agreed orders. The 3 agreed orders resulted in a rendering, being entitled to a $30,000 and $30,500 in administrative penalties, and of that $30,500, we collected all of it. There are no licenses revoked, no license suspended, no license denied or revoked due to criminal history action, no cease and desist orders, and 8 cases were informally resolved in that manner in some manner that I referred to, one of the manners I referred to earlier. Now, the next section is allegations versus disciplinary action. So when a complaint is filed, they include allegations of violations of the program, a rule in law was violated. However, there's a big difference between what is alleged and what we can prove. As you can see, there were 11 allegations made in this program, and of those 11, we were actually able to proceed on 4 of them. So yeah, there's a lot of, I guess, attenuation between the two. Now, if we could move on to the next page, you'll see this is the same set of summaries, but this time for fiscal year 2020. While these are relevant to the board's decisions, I don't want to linger too long on them, as they're essentially just restate what I said earlier. So if we could just proceed to the case summaries, yes, thank you. Case highlights. These are the 3 cases in 2020 that we resolved with the disciplinary, that can be categorized as being resolved with disciplinary action. The first, against Dale Stewart Lee Sheen, was based on 2 separate cases, in which each of them having 2 separate counts of fraud, deceit, gross negligence, and malpractice. The second case for fitting a prosthesis without first obtaining a valid prescription. Before both these cases were set to be heard in front of the State Office of Administrative Hearing, where the court ordered the 2 parties into mediation to settle. The terms of the settlement agreement were drafted as a result of that mediation, and the terms include respondent's agreement to pay an administrative penalty of $30,000, to reimburse one of his victims of fraud for $12,000, that Blue Cross and Blue Shield, and $20,000 to Medicaid. He also agreed to participate in quarterly inspections of his records and to the imposition of a 3-year suspension of his license. Now, this suspension was probated, meaning that it didn't actually go into effect for that during that 3-year period. But that probation of the suspension is conditioned on the respondent's continuing adherence to all the terms of the settlement agreement. If he does bust those terms, then the suspension kicks in. Now, there are only 2 cases remaining on the next page. Yes, thank you. One against Jeffrey J. Peterman. This was the violation alleged was providing a prosthetic care in an unaccredited facility. The respondent agreed to settle for a $750 administrative penalty, and that resolved this issue. The third case, Anthony P. Eamon, was provided services with an expired prosthesis license, and he agreed to pay an administrative penalty of $500. By the way, I apologize. I was practicing these words, and they just not really getting out very well. But anyway, that concludes my section of the report. I'm happy to answer any questions that you might have.
Does anybody have any questions? All right, I've got a couple.
Sure.
On the page where it is laid out the alleged violation and then the actual violations, and you said, alleged is one thing, we have to be able to prove it for it to become a violation.
That's correct. Yeah.
Okay, when those concerns include standard of care issues, who is making the decision as to whether you have evidence or whether you can try to get the evidence to help substantiate the alleged violation?
No, I mean, it's a great question, because many of these allegations are, especially the consumer complaint driven ones, are based on what are essentially standard of care violations. I'm not qualified to make those calls. So we have experts, retained experts, and also this is a good time as any to send out a broad request for any professionals who are interested in becoming an expert witness with the department. We could really use your services. We have an online form for the applications. We'd be happy to consider any applications that we might receive. But anyway, once those experts are retained, we send the entire investigatory file and all the evidence that we've gathered over to them, along with a series of questions to determine whether the complaint allegations are valid or not. We don't make that call. We get a report back and base further actions on that expert's conclusions.
Okay, and without naming names, how many experts do we have signed up or retained to help with this right now?
I believe there is a we always need more expert witnesses, frankly. And I do think that there's maybe one in this profession. We have not received many applications for the role of expert here. And so, fortunately, we don't really have, this is, as you saw earlier, there are not a lot of cases filed, but frankly, those cases that are filed, we're almost certainly going to need an expert with them if we're going to proceed. So it's they stay open longer than we'd like.
Okay, thank you. And then one more question on one of the cases,
Yes.
the first case that you highlighted, Mr. Sheen.
I believe you were the expert on that one, right?
Yes.
Yeah.
Yes. So one of the requirements was the audit, the chart audit, and I'm wondering if that is occurring, and I'm wondering who's doing them.
Yeah. So I actually had that same question. Due to the nature of the audit, where it has to be without warning, without notice, yes, and it needs to be conducted on site, because if we give any advance notice that the respondent would receive, could give him the opportunity to hide records that he doesn't want us to find. But due to COVID, our investigatory teams has faced some pretty restrictive measures on their ability to perform on-site investigations, and unfortunately, this has suffered as well. Typically, our investigators are able to do like what they call a virtual inspection, conducted over video conferencing or the like. But this is one of those things that you can't really do with video conferencing, just because that would give them notice that, hey, we're looking at your records. I hope that once Delta kind of subsides, we'll be able to do more on sites. But right now, we're just, I guess, realistically prohibited from doing anything.
So, given the situation, that means none of these audits have been done yet.
No,
Okay.
oh, sorry, go ahead.
Yeah, so will we be able to extend the time period that we are going to do these audits, or are we still confined to the 3 years?
Well, we can, agreed orders are essentially a contract between the parties, and contracts can be renegotiated. I don't want to speak too much about this, in the fear of like potentially sinking this case down the line. But I would say that academically, yeah, we can renegotiate the terms. But let me see when the actual agreed order was rendered. I believe it was. I'm just looking for when Brian actually signed it. But anyway, that is the start date. Whatever date he signed it, like that's when the 3 years starts. So I think it was relatively, I want to say, yeah, there it is, November 16th, 2020. So we've got 3 years from that date. So we've got some time to conduct these audits within the parameters set by the agreed order.
All right. So thank you very much. And just to reiterate what you said to the general public that's maybe watching this, if anybody would like to volunteer to be an expert witness and to help us out with cases in the future, where would they find that application online?
So yeah, they would go to our website, tdlr.gov, and let me get the link and get back to you. I can post that. I have that posted, I guess, in the video conference so that public can see it.
Could it also be posted on our orthotic and prosthetic page within TDLR?
Oh, sure. Yeah. Well, yeah. I hate to speak for IT, but I don't see why that would be a problem.
Okay. I think that'd be a great place to post it, since that's where our public goes.
Yeah, that's true. I'll go ahead and I'll get that link out to you, and also see what we can do about have it posted directly on y'all's page.
Okay, thank you very much, Chris. I appreciate it. Anybody else have any questions? Okay. All right, then moving on to the next item. It's number 4, and it's Education and Examination Division, and we're going to hear from Michael Strong.
Good morning, Chair and board members. My name is Michael Strong. I'm the manager for the Education Examination Division, and here to give you our stats for this reporting period. First up, jurisprudence examinations. We had 128 for fiscal year 21. You kind of heard Leonard talk about it, where September's data was not ready. Same thing for fiscal year 22 for our September data. For jurisprudence examinations, we didn't have those yet, but we have the entirety of FY21 available. You'll see it's slightly lower than FY20 was. We don't have an explanation for that, and without looking into further years, I don't know if that's just a trend with renewals or something that's planning going up or down moving forward. On to the next page. Continuing education audits, you will notice for a significant part of FY20 and for fiscal year 21, there were no continuing education audits performed. This is where we're sending out letters to our health professions auditing their CE courses. This was discontinued as a department decision during COVID, and as we are looking to reinstate that process in January of 2022. So for the remainder of this year, you will still see that there are no continuing education audits, and beginning in January, the first working day of that year, we will begin doing continuing education audits for all health professions moving forward. Going down to our updates, we're also letting every industry know that Education Examination Division is moving to a new system called Dynamics. Previously, we worked solely out of Outlook, or for regular emails. Dynamics is a system that allows users to fill out a web form, contact the department, state all of their needs, their license information, upload attachments, and it sends it to us. Then we are able to work smarter. We can actually see which industries are contacting us about which problems or which issues the most often, and that allows us to fix issues moving forward rather than just always being reactionary. So if we see that there's a lot of questions leading towards one type of scenario, whether it be how to register or take a jurisprudence examination or anything else, we can make sure that our information on the website is clear. If we need to update forms or if we need to send out government delivery notices out to the entire industry to alert them to specific changes in a program. This is a tool that's going to allow us to work much smarter instead of harder all the time. We still work hard, but we want to be smart. We want to make sure that we're putting our best foot forward and that we are making information presentable, accessible, and easy to understand for all of our community. With that being said, that concludes my updates, and I'm open to any questions that you may have.
Do we have any questions from the board? All right, and this time I don't have any questions. Thank you very much. All right, moving on to number 5, the Regulatory Program Management Division, and we're going to hear from Steve.
Good morning, advisory board members. My name is Steve Eaker, and I'll be giving the RPM update. I'd like to start with some personnel updates. First, the medical and health professions section has 2 new staff members. Angela Sanders and Sean O'Neill joined our section this February. Angela has worked for TDLR since 2017, and Sean has been with TDLR since 2005. Both previously worked in the field inspections division, and they are wonderful people and a great addition to our team. Currently, we've worked with the Office of General Counsel and several other divisions to complete the 4-year rule review, or the orthotic and prosthetic rules. The goal of the review was to simplify and streamline the rules, as well as identify any rules that needed to be added, amended, repealed to align them with statutory requirements and current policies, procedures, and practices. The result of the review will be presented today in just a few minutes. Staff also recently worked to update the program webpage to improve clarity and ease of use. Some updates include providing a clear description of the types of continuing education that meets the criteria for in-person, and the process to obtain approval prior to beginning a clinical residency for assistants. We've also worked with the Office of General Counsel and other divisions to draft rules for telehealth and disaster response. And myself, along with Stuart Myrick, we continue to assist the Texas Department of Division of Emergency Management State Ops Center in support of the state's COVID-19 response. We look forward to attending any upcoming conferences, meetings, or events. And if you're aware of any outreach opportunities, please share them with me. Also, I wanted to mention we're looking forward to working with customer service with regard to the more focused training for the different programs. We had a program like that called A Closer Look, and we're going to restart that. Also, as part of our outreach, we always plug expert witnesses. So I look forward to attending conferences where we have a whole blurb on that and the department's need for expert witnesses, because we do not have the in-depth education to assess some of these complaints, and we need your help. And that is about it.
All right, thank you very much, Steve. Do we have any questions from the board? No, and I don't either, so appreciate that.
Sure.
Number 6 is Field Inspection Division, and we are going to hear from Juan Munoz.
Good morning, members of the board. My name is Juan Munoz. I'm a field manager for field inspections, and I will be doing reading a report to you this morning. One thing just to bring up from last year, as you all are probably aware, we lost, or Tanya Guthrie retired, and Eric Beverly did accept the position for the new director of field inspections, and that was in February of this year. And he was already part of TDLR, somebody I may already know, part of the Office of Strategic Communication. And as Steve mentioned, we did lose some great assets of ours, Angela Sanders and Sean O'Neill. They went to RPM, so we do thank them for what they did for us in field inspections. In August 18th of this year, we did lose James Turner. He was with us as an inspector originally, and then accepted a position in September of 2019 as a field liaison. But when that occurred, we were able to promote Delinda Jew. She accepted the promotion as a new liaison, and she started effective September of this year. So I want to congratulate her for coming on board. Next, I'd like to discuss a little bit on the statistics for our inspections. As you'll notice, we had slow year due to COVID. We have picked up our inspections. Currently, there as of this report, there were 56. I would like to add there's approximately 15 or so that occurred during the month of September that are not reflected on this report. But we are in the process of getting caught up, as we are with all of our other programs, because we are behind in many of our other programs as well. So we are working on the backlogs of our OPS, or orthotics and prosthetics facility inspections. We can move on to our most common violations. Nothing really hasn't really changed very much from our previous most common violations. A lot of it has to do with documenting training for some of the equipment that they may have in the facilities. If they have a new practitioner on site, sometimes we find those violations, some minor things like that, or just something simple as a visible signage that lets them know what the hours of operation for the facility. So minor violations in most cases. And finally, for our current projects, just like to make mention that we do have 3 new inspectors that have recently completed our OPS training and have been released to perform inspections. These are from the East Region. Lindsay Wren completed training in August 2020, and in our North Region, we had 2 inspectors, Heather Allen and Lance Carolyn, that also completed that training in September 2020, which will help us reach areas that are kind of in in far out areas, East and West Texas. Division Liaison Ulysses also conducted a refresher training for the program September 2021. Again, we've been out of the field doing inspections, so we just need to do a refresher, make sure that everybody was still current on the most updated violations. For a COVID response, something to note is as of August 31st, 2021, the division has completed 4 desk audit and virtual inspections for the orthotics and prosthetic facilities. And also to mention that we were allowed to enter into inspections in all areas in the state as of April 6th of this year. And that concludes my report, unless y'all have any questions for me.
All right. Do we have any questions from any of the board members? Okay, I do have just one quick question. You said that the 3 new inspectors recently completed training. Who is training them and how?
Well, that's a combination. Usually that occurs with our liaison. So Ulysses Ocio, who's been part of the program since inception, since it came to TDLR, he's been very active in that program. And then we do a little bit of our classroom portion, and then we do a lot of our field training as well. So on-site kind of training with those inspectors, and that's usually done by liaison or somebody who's well versed or has been doing the training. I'm sorry, been doing the inspections for quite a while.
Okay, all right. I just want to go ahead and offer out on this area as well, as I know when we first came under TDLR, we did some training for inspectors and some training for the investigators as well. And I forgot to mention this when Chris was speaking. But if you all ever have any questions or you see an opportunity for someone on the board to offer some specialized training in O&P in particular, I know we took some of the inspectors into a couple of facilities and actually walked them through the facility to point things out that maybe an untrained eye would not see. So if you all ever have any need for something like that, please reach out to some board members for some guidance there.
Yes, ma'am. Absolutely, that would be great. Yes.
Okay, thank you very much.
Thank
Appreciate
you very
that.
much. Yes, ma'am.
All right, then moving on to our last area, it's the executive office, and we're going to hear from David Gonzalez.
Good morning, Presiding Officer Mize, Advisory Board members. Truly appreciate y'all being here. It's been a little bit of time since y'all seen this face and that we've been able to gather together. So I will remind you, my name is David Gonzalez. I am the Deputy Executive Director of Licensing Services. So I oversee the Licensing Division, Education Examination Division, and also our Customer Service Division. There's 2 other deputies, and Brian Francis's infinite wisdom, he knew he needed some help. He's a large personality, got some big shoulders, but he needed a couple other deputies to help. And so we have our Finance and Operations Deputy Executive Director Mike Adis Mendez overseeing that aspect. Miss Christina Kaiser oversees our regulatory programs, enforcement, and field operations divisions. I'll be giving the executive report today. I'm going to try to keep it brief. We've been very busy this past legislative session. As we have been over the 26 years that I've been at this agency, I don't think I can say we've ever had a slow legislative session. But this particular session was very significant for us because it included our sunset review. The sunset review came in the form of House Bill 1560, and it was actually on the very last day of session that bill got passed, which had us on pins and needles on whether or not our agency was going to be continued for a length of time. That's a pretty big deal for us, and it was a goal of ours to actually survive our sunset session. I think we came out actually pretty well. The results of sunset means we have some work to do. And that's the case with every legislative session. There's bills that have to be implemented. The sunset bill in particular had some guidance provided to us. There's some deregulation of programs, a couple of new additions to programs as well. So there's things that our agency is doing as a group. We have every division represented in what we call bill implementation teams, reviewing the statutory changes and doing what they can to communicate with each other and with the public on how things are going to change and shift based on the statutory changes. I'm going to bring your attention, and I'm going to try to wing it and share a screen. See if I can share the right screen. All right, so hopefully you will see our website pop up. Is everybody seeing our website?
Yes.
All right. So what I want to bring to your attention is most of our communications, kind of what Miss Dawn pointed out from our customer service division, we try to do through our website, but it only works if we have people looking at the website, knowing where to find things. Presiding Officer Mize, your suggestion that we put advertising out for more experts on the website, that is an excellent suggestion. So we will make sure that happens. We'll get with the IT section. What I wanted to bring to y'all's attention is the 87th legislature for new laws is a new link on the front. We've always had some kind of connection to what was going on under the session, but this one has a summary of some of the bills that were more influential on changes here at TDLR, and they give summaries. This is how we do our best to try to communicate with the public on things that are changing around TDLR and how we may be going about implementing these requirements. So I just point this out so that if there's any desire to go into more detail about all the different programs, because we have several of them, you can look at this on our website. And I'm going to try to stop sharing. And continue on with the discussion. So for our bill implementation teams, it does require input from the public. We can't do this all on our own. We're actually taking part right now. We had a 4-year review and bill implementation changes that are going to require work groups. They're going to require input from the public. So the people that are listening at home, it's very important that y'all do get signed onto our list server and pay attention to these meetings, because this is your opportunity to give us the input, as Mr. Phipps described in his brief summary of how our rule process works. So thank you again, advisory board members. When we don't have a large audience or there's not a lot of participants, we are really relying on your expertise, along with the expertise of our general counsel and our enforcement investigators, our regulatory program management division staff, on their historical knowledge and their experience on how these things may work. But again, without y'all, we don't have that balance. We don't have that check. So taking advantage of these opportunities, participating in these meetings is the best way to keep a pulse on your industry and the things that are happening. I'd like to bring up the stats, Miss Anna, if you could help me with that. So every program, we try to keep the statistics on what pages on our website are being visited. The Orthotist and Prosthetists website has had 10,469 views in the past 6 months. Administrative rules, forms, applying for a license, frequently asked questions, and facility accreditation have been the most popular sites. If there's things that we can do on our webpage that'll make it easier for your industry to get their information or would better serve them, bringing these things up to our attention, like you did, Ms. Mize, is very important. So we're open and transparent as we can be. We want to hear from the public of what we can do better. And I just take pride in all of our staff, the way they try to do their job. When Miss Dawn Robinson was talking about customer service, she talked about the job that her staff do, trying to be generalist and know where to navigate our website and point people in the right direction for questions that are a little on the easier side. There is some additional questions that come in that go beyond our expertise, and we have to get technical assistance. Typically, we rely on regulatory program management like Steve Euchre or enforcement division, and we'll guide them to those divisions when appropriate. But at some point, sometimes it goes even beyond that. And again, the advisory board members may be the technical experts that we have to rely upon. Having more than one or a few is very important for our success. So just want to make sure that we keep plugging for participation and as much input as we can get, because this is what makes the program progress. I think that's all I had to share. I'm not, if there's any specific questions related to the 87th legislative session or to the statistics, I'll be glad to answer them.
All right, thank you very much. Are there any questions from the board members? I do have a couple of questions for you myself.
Sure.
How many programs does TDLR now govern?
40 programs. There's always argument and discussion amongst our staff on which one should count as a program and which one is just a smaller subset of the program. But I think the number we're going with in our next strategic plan is going to be 40.
And how many of those are medical?
Ooh, wasn't prepared for that question. I'm thinking at least 12, but I would have to look at them because medical is one of those terms that we have some massage therapy program would not like to be included in the medical side. So I'll have to look into that and get that answer back to you, Ms. Mize, because I don't want to get it wrong.
That's fine, that's fine. Thank you very much. I knew you guys were continuously growing. I just didn't know how much you had grown, so I'm glad you've gotten more help. That's a lot of growth. Uh, so a couple of questions on that. The 4-year review that the staff has been undertaking, after they completed the review, they sent out their proposed changes to our work groups, appropriate work groups for comment. And I'm wondering, could it be considered next time, which I guess is in 4 years, that the work groups be involved on the front end instead of the tail end of that process?
So I know that we had some commitment to try to get the work group since our last meeting. We definitely had some time. We had some COVID going in the middle there. It's not too late to get input from our work groups, and I want to commit that to you right now. So these draft rules will be going out for input. There is still time to get input from our advisory board members on those rules. We're going to be getting feedback, obviously, from the public. So there's an opportunity still, but I hear you loud and clear. Getting y'all's input up front is a better way to go. Typically, we get those ideas for our rule proposals from our strategic plans. And I think y'all had an opportunity to participate in our strategic plan, which would have happened in March, April of 2020. I know January was the last meeting that we had, but in March, April of 2020, we had a virtual strategic plan session where we're taking all the input. We asked those questions, and you may have forgotten because it's been a little bit of time. We asked those questions. What are we doing well? What can we do better? If you were king or queen for a day, what one thing would you change? Now, sometimes those ideas aren't fresh on your mind at that time that we're asking the questions. So if something has come up since then, you've seen some enforcement actions that you think we can do a better job on. You've seen some licensing processes that we think we can do a better job on. There's always an opportunity to submit rules, and you don't have to wait for the 4-year review period to submit those. It just makes it easier, makes it more comprehensive to implement those and communicate with the public. But there's still an opportunity, Ms. Mize and advisory board members, to get y'all's input during this process. So while the public comment is looking at these rules, y'all can give us y'all's insight on the things that we might need to still improve upon, and we can consider whether or not we need to move ahead, or if we need to repost and get a public comment opportunity again. Does that
Okay.
help?
Yes, it does. And the reason I asked that question is as I was reviewing some of the proposed rule changes in the work group, I discovered 1 or 2 areas that needed addressing that were not in, that had not been identified.
Okay.
And so I proposed those and then was told that they couldn't be considered in this package, that we'd have to do it in the next package. And so that's what precipitated that question, is just, you know, I guess maybe if I had been involved on the front end, I would have thought of that, but there's also a chance I wouldn't have seen it. So
You're absolutely right. If we had David Gonzalez, TDLR, you're absolutely right. If we incorporated you ahead of time, you might have caught it beforehand. Again, as part of this package, we may not be able to open up that particular rule section without having to repost everything that we've worked on so far. But again, we don't have to wait for the 4-year review to look at these and start working on the next package. It just means that we may have a 1 or 2 advisory board gatherings more than we would have expected. And so, yeah, definitely want to be more effective and more efficient, since we don't get y'all together too often. These advisory board meetings have been approved by the legislature now going forward to be virtual for TDLR, which has been a big deal for us with quorums. And again, since we don't reimburse her for y'all's travel, having people to be able to participate without taking an extra 2 or 3 days out of their work history. So same thing should be able to apply for work groups. Communicating should be easier for us virtually, and we should be able to gather that input. So point well taken, Ms. Mize.
well, thank you very much. One last question. If we do see something on our website that we think could be clarified or posted or added, or have any opinions about it, who's the best person to send that to?
So we have a web administrator. Mr. Fickle's actually on this line. He helps coordinate a lot of these things, but he's got some help. It depends on what page it's on, how easy it would be. I'm going to say go ahead and send it to advisory board. That way they can be the central location, and they will forward it on to the division that's going to be most appropriate with updating their pages. Every division has a part. Licensing takes care of their forms and stuff. Enforcement takes care of their pages. So I think advisory board would be the most appropriate place to send that. That way we can make sure it gets to the right person, and we'll get it updated as quickly as we can.
And so does that mean you, Anna?
Yes, you can send it to me. You can send it to advisory.boards email address. There's 4 people that get that one as well. And Chris Funderburg also wanted to let y'all know that he has submitted a request to IT to add the expert witness link to y'all's website. So that's already in the works.
Perfect. All right.
And one more thing, Ms. Mize, I don't want to put Mr. Euchre on the spot, but if he's had a little bit of time to look at medical programs, could you give me an estimate or help me out with that number, Steve?
Oh, the number of medical programs?
Yes, sir.
I have not. I would say we have.
I'm sorry, I put you on the spot.
Like you said, that term is bandied back and forth. I'd say we at least have 10.
All
I
right,
could kind
so
of jump in maybe and help a little bit. This is Alex Phipps, the Assistant General Counsel.
thank you, Alex.
There are 10 programs in Title III of the Occupations Code, and so that generally would be your health professions. I don't think I would use the term medical for those because massage is one of those programs. Not to say that massage doesn't involve the health of a human being, but it obviously is not necessarily medically based. So that term it's hard to define, as David and Steve have said. Medical typically is really only reserved for physicians and the Texas Medical Board. So we use the term health professions here at TDLR. And, generally I would say 9 to 10, depending on how you would define massage.
David Gonzalez, TDLR. Thank you, Steve, for letting me put you on the spot. I always trust in our staff, and Alex for stepping in. This is how we typically work at TDLR. Every viewpoint is important to our bill implementation teams and the work we do, and especially from our advisory board. So, Ms. Mize, I appreciate the questions.
Thank you, Mr. Gonzalez. I appreciate it. So that wraps up this section of the meeting. And if everyone is okay with this, I would like to call a recess very, very quick for like 5 minutes. And then we will come back, and our next session that we will be jumping into is the rule proposals. And I don't think it's going to take too long, but I want to give people a chance before we jump into that. So I'm going to call a recess at 11:17, and we will come back at 11:22.
Thank you.
Thank you. So I'd like to call us back to order at 11:22, and we will proceed with the meeting. The next item on our agenda is item H, and this is the discussion and possible recommendation on the proposed amendments to the existing rules at the 16 Texas Administrative Code, Chapter 114 for Orthotics and Prosthetics. And before we jump into this, I would like to say that the job that was done by our teams to propose these changes is very good. And I didn't realize how much cleanup needed to be done until I started reading these changes. And so I think that this is going to go fairly quick because it all is pretty straightforward. And I just want to tell everybody that worked on it at TDLR that y'all did a great job, and thank you very much. So I'm going to hand this over to Alex Phipps, the Assistant General Counsel, and he's going to guide us through it. Thanks, Alex.
Sure, thank you. And again, Alex Phipps, Assistant General Counsel, and hello again, board members. I'm here to present this rule package. And the way I'm going to present this, since this does involve a lot of different rule sections, I'm going to give you a broad overview of what the package is, and then I'm going to walk section by section through the changes and give you a short summary of each section's changes. And then we do have two changes that were identified after the packet was sent out to you that I'm going to show you in detail by sharing my screen so that you can see the line edit from the packet you have in front of you, just to make sure there's no confusion. So we're going to go through that. And of course, if you have any questions at any time, or you can't hear me, or you have some issues seeing my screen, just let me know. I'll stop and try and address that for you. So no further ado, we'll go forward. The package that we have for you today here in Chapter 114 arose from staff's review of the existing rules after the 4-year rule review that I discussed earlier in the presentation, and you've heard several different people mention it. It's required by the Administrative Procedure Act for every state agency to review their rules on a 4-year timeline. At TDLR, we take that a step further and we do implement a staff review of the rules at that same time. So that is an additional step where staff is looking for issues that are redundant or might generate confusion, or maybe issues that are not reflecting the accurate way that the agency, administers the program currently. So you do have some outdated language that may be identified. You may have some provisions that are redundant with other provisions in the chapter. You may just have errors that need to be corrected. And so staff went about finding those by holding multi-division meetings, sharing drafts, and submitting suggestions. And every division that has spoken to you today was represented in those multi-division meetings and has participated in some way in these rule reviews. And this is not just for this program, of course, it's for all TDLR programs, but the package we have today did arise from Chapter 114 and those reviews that we conducted earlier this year. So walking through the specific sections that we have for you, the first section that we're amending is section 114.20, and that's the application section. We're going to be amending that section to permit submission of official transcripts and references in a manner prescribed by the department, which will allow us to accept transcripts in many different formats and to be flexible in the future if formats do change. We're also eliminating the requirement to submit proof of completion of the jurisprudence examination at every other renewal. And you'll see that change in several other sections as well. This change is to harmonize the program with other health programs we have here at TDLR, where the jurisprudence exam is not required at every other renewal. It's only required at initial application. And you'll see that change multiple times throughout the rules where that's mentioned. And we're also removing outdated language regarding the disapproval of applications. Disapproval of applications is not the terminology that's commonly used today to talk about denial of someone who files an application. And it's redundant with another section in our rules, 114.90, which is a broader section that covers all disciplinary grounds for action. So removing this section eliminates some confusion and gets rid of archaic language that might create a problem. And again, that's just an example of what staff would discuss and identify as something that may be an issue. Moving on to 114.21, this is the licenses and licensing procedures section. we're amending this section by eliminating a reference to the jurisprudence exam again. And then we're clarifying the language requiring display of a license at the primary location of practice or place of employment to reduce confusion. The next section that we're amending is 114.22. This is examination for licensure as a prosthetist, orthotist, or prosthetist, orthotist. We are amending this section by inserting a reference to initial applicants completing the jurisprudence exam. So what we're doing here is pulling that reference up to 114.22. So it's still required, it's just been moved around in the section to make it more clear that that's something that needs to be completed. We're also removing outdated language regarding the administration of the examination by the department, because the department does not directly administer the exam, it does utilize a designee. And we're also making clarifying changes to the section to reflect the current practices of the department and its designee regarding the examination. So again, removing archaic language and older language and trying to update that to reflect the current practices of the department. Moving on to 114.27. This is the assistant license section.
Sir?
Yes.
Is it best for me to ask questions as we're going through this, or do I wait till you're completely finished?
Feel free to ask your question at any time, but if it's about a specific alteration or change that you sent to me, we do have those two changes as a document that I will share and put up on my screen. So if that's the question that you have, I can do that later in the presentation.
Okay, right, thank you.
Sure. So going back to 114.27, this is the assistant license section. This section was a clerical error on behalf of the department. The department inserted text into subsection C that was a mistake. That was, again, on the department, most likely a former legal assistant who's no longer with us. But again, the text is incorrect. The text needs to be updated to the text as it was before September 1st, 2018. So we have inserted effectively exactly what was in this section before that error occurred. And that reflects what actions were taken by this advisory board and by the commission back when the rule was amended in September of 2018. Again, this section was not touched and should not have been amended. And so we are cleaning up our own mess in this section to make sure that it's accurate and reflects what should be there.
Alex, I'm sorry to
yeah.
interrupt. Anna
Sure.
Clark, TDLR. Were you going to share your screen to show the changes?
I'm going to do that after I talk about the summaries for each subsection. I have two changes that Ms. Mize requested that I have a separate Word document that I will share and walk the board members through so that they can see the line edits versus what they have currently in front of them.
Thank you so much.
But of course, if anyone has any questions or would like to interrupt, feel free to do so. Okay, I'll get back to that summary. So talking about 114.29 now, this is the accreditation facilities. We are amending this section to simplify the submission requirements for changing a practitioner in charge or a safety manager. And we're eliminating the reference to submitting a fee for changing either of those positions. And you'll see a corresponding amendment later in the fee section where we are eliminating the fee for changing either of those positions. So the changes to this section are just to clarify that. 114.40 is the next section we're amending. This is the renewal section. We're removing the requirement to submit proof of the jurisprudence exam at every other renewal, as I mentioned previously. And we are changing the process for voluntary charity care license holders by eliminating the delay until the next renewal period they wish to reinstate their license to active status. So currently, we have them sitting on the sidelines until their next renewal where they can change back to active. The goal of this change is to make it possible to switch at any time if you are on voluntary charity care. You will need to pay back the amount that you should have paid to be voluntary or to be active status instead of voluntary charity care. But we don't want people having to sit on the sidelines for up to 2 years if they decide they no longer want to be in voluntary charity care status. So that's the goal of changing that section. 114.50 is the next section that I'm going to discuss, and that's continuing education. Our changes here are to clarify that live instructor-directed activities may be offered in person or using telecommunications or information technology, as long as it permits instantaneous two-way interaction between the instructor and the attendee. We're also changing the classification of interactive computer-generated learning activities as a self-study activity, making it clear that that's the category that that computer-generated learning will fall under. And then we're going to make clarifying edits to that section based on those 2 changes. Obviously, those changes came out of experiences during the pandemic to ensure that if you are attending a teleconference or another sort of conference that is live and interactive, if it is virtual, but you do have the ability to interact with the presenter through a 2-way medium, that will be acceptable as continuing education. And additionally, we wanted to clarify that versus the computer-generated version, which is more akin to a self-study activity. We want to make sure those 2 are not classified in the same category. And that's the purpose of the change to 114.50.
So I have a question here.
Yep.
And you may have just answered it with your last sentence.
Okay.
But what has started occurring in our profession is that we will, for instance, in September, we had one of our national meetings in Boston, and it was in person, but you could sign up to attend that meeting in person, or you could sign up to attend that meeting virtually after the fact. And so I don't remember, it was maybe 2 weeks later. If you signed up to do it virtually, then you could take it then. And they showed all the exact same presentations. It operated the same way. However, in that format, there was no live interaction. So that, I think what you just said is that set of classes, which was 3 days worth of presentations, depending on if you showed up in person, counts one way, but if you took it after the fact, it counts a different way. Is that correct?
I'm not going to be able to speculate about how exactly that would be classified without having the information in front of me and being able to review it. But I will say that generally the concept is that if you're going to give a conference that's pre-recorded, normally you expect there to be an instructor or some sort of proctor that is monitoring the attendees. And the goal there is to ensure that people are actually utilizing the conference appropriately. We pulled this language from other programs that we have with similar qualifications. Of course, if the advisory board wants to change this qualification, you can suggest a change to this proposed language that would broaden that category and remove the 2-way communication if that's something that the advisory board members are interested in. We wanted to start with the more restrictive language to ensure that there was no danger of being overly broad and permitting things that this advisory board is not interested in permitting. But of course, you do have the ability to suggest whatever language you think is appropriate.
Is this the appropriate time to discuss it?
Certainly.
Okay. So I do think we need to discuss this because I think it's going to be very confusing in the fact that I went to Boston and attended it live, but somebody else that signed up to take it virtually 2 weeks later, according to this language, I believe that's going to count differently because I don't think, did anybody on our board take the AOPA courses after the fact virtually? No? Okay. I've seen it done both ways, where after the fact they do ask the instructors to engage with any questions that occur at the end of their pre-record or their recorded session. But I don't think that happened with the AOPA session this time. So I just think that's going to be an open window for a whole lot of confusion if we try to take the exact set of coursework and classify it in 2 different categories based on how you take it. Any other comments? Yes, Mark.
My concern would be is there is not a lot available one-on-one interaction via the internet for courses to separate these out right now in our industry. So most of them are going to be, I guess, the self course that you go through and you take an exam at the end. There's just not enough available in that other criteria at this moment. So I think it's going to be hard to get CEUs for our Orthotists and Prosthetists in Texas, just for the fact that a lot of people are still concerned about travel and they don't want, there's not a lot being out there that's offered right now, but the ones that are, there are certain individuals that still do not want to travel because of the COVID related issues.
So Meaning that you agree with my concern on this wording.
Yes, I agree with where you're going down that path, Catherine.
Okay. Any other, Randy, David?
I don't have anything to add.
Okay, so so the proposed language that I have scribbled in on my work here is that, well, I don't have exact language scribbled in here.
I can
Maybe it's
suggest
to remove,
a change.
okay, remove the
if
word
you-
live.
No,
instantaneous.
unfortunately, the structure of the way that section reads would need to be changed pretty drastically for getting rid of live. What I was going to suggest was to get rid of the permits instantaneous two-way interaction between the instructor and the attendee, and to replace that with, you know, the telecommunications or information technology presentation that was given live and maybe pre-recorded, or some version of that language.
Okay. Yeah, that was my other thing that I had marked, is the word instantaneous. So there's another form of CEUs. So we have two national meetings. One that's presented by the Academy, American Academy, and the other one is presented by the it's AOPA, American Orthotic and Prosthetic Association. And I would expect going forward that those are going to be offered live, in person. And then, like I said, after the fact, that you can take it, but you're just not going to have the interactive part if you take it after the fact. The other type of courses that we have offered are offered from our vendors, our manufacturers that, let's say, have a new prosthetic foot on the market and they want to do education on that foot. And so they'll get it approved for in several hours or 1 hour or whatever. And that most likely will not be interactive. Do we want to try to differentiate between the meetings? Oh, I guess we also have our Texas Society meetings. Do we want to try to differentiate between our 3 major meetings and the courses that you sign up with through Ottobock or OSER directly? Yes, Mark?
Mark Kirchner, did the AOPA meeting, did they have a self-assessment like they normally do in person, where after a presentation, there's always a requester form that they ask every practitioner or certifee to fill out that states what were the questions, where were the answers, was it, you know, proper for our industry, did we get anything out of it? Was there something through the recorded version of that afterwards?
I didn't watch the recorded version, so I can't accurately answer that question. Like I said, I did the live attendee. Now, I can tell you that I would have to ask Eve Lee, but I do believe they have the ability to look and see if somebody clicked on it to watch it and they watched the whole thing or not. But I think that would be important, because if you're just clicking on it and then closing it and moving on, I don't want that counted. So I can find that out from AOPA, and I can find it out from the Academy too, if they're going to have any kind of a monitoring system for attendance through an entire class or course that you take. Alex, how should we proceed with this piece?
Well, you know, I have that suggested language that I'm happy to insert, including a pre-recorded, you know, version of the live conference, if you'd like for us to do that. Or we can pull this rule out of the proposed package, send it to a work group, and have them consider it further before putting it forward.
Okay. And can we do that and keep this rule package together if we send it to a work group?
We'll need to remove this section if you want to change the language that we currently have. We don't want to propose language that we know we're going to alter. So we'll need to remove 114.50 from the list of the rules that we're proposing if you'd like to have the work group work on changes to this language. Otherwise, we'd be in the position of proposing it and then knowing that we're going to alter it and having to propose it again.
Okay, so if we refer it to the work group, when will it be reconsidered to go through the process? Because I know the process is lengthy.
We would have to depend on when the work group meets, how many changes would be made to the rule, when the next meetings of this advisory board would occur. Any comments that are received once it's proposed. It's very hard to speculate how long it would take this specific rule to work its way through the proposal process.
But right now, you could take out the wording of instantaneous and it could proceed.
Sure. I mean, we can put up language that we feel we're comfortable with and put that forward as a proposal today, and we will include that in the packet that's published. I'll just need to make sure that this board is comfortable with me proposing that language. And we can do that through some line edits right now. I could sit here and work on it. We could take a short recess, whatever you'd like to do.
And I can send out a quick request to both of these entities and see if I can get a quick answer on whether they do monitor the attendance through the entire course.
Well, I guess one important question to have in this situation is, what is the section of this new language that the advisory board is not comfortable including? Because if we want to just remove that permits instantaneous two-way interaction between the instructor and the attendee and replace that with something like including live courses that were pre-recorded, we could do that very quickly, but that's not going to address the assessment portion. So if there is a desire for a verification of attendance or a post-presentation assessment of some kind, we'll probably need to include a little bit more language to clarify that that does fall into the live instructor given category.
Steve Eaker, TDLR, if I may. I think the intent is to allow live, interactive, remote CE. And so the language should reflect that. At a conference, when you're listening to a lecture that's live and interactive, there may not be and probably won't be any kind of post-assessment because it's not a specific course, covering a specific type of procedure. So I don't know if you'd want to have, an assessment required. I think you just want to nail down which we feel is already in the rule, that attending a remote a conference that is occurring live remotely is okay.
Okay, but understanding that in our case, for our profession, you're not attending it while it's live, you're attending it 2 weeks later after it's been recorded. Now, I can say that they did record any questions and interaction that occurred at the end of each presentation. So the recording didn't stop when the speaker quit speaking. It did include any interactive questions that followed. I do know that. So if we're okay with that, then, and I kind of think we should be, I think just removing the instantaneous exchange is going to cover us okay.
So just to clarify, and if any other advisory board members have any comment, let me know. The edit that is being requested now is to delete everything after using telecommunications or information technology. The text that will be deleted is that permits instantaneous two-way interaction between the instructor and the attendee. And that's the full extent of the change that's being requested.
Okay, we had a question or a comment from David.
Go ahead.
Yeah, I'm not a member of the public, so I'm not actually in the industry, but out of curiosity, is something like a conference or a meeting, is that considered continuing education?
The portions of the conference that are educational in nature have all been approved for CEs prior to. So when we go to that, we do organizational meetings, and those are not counted. But the instructors that are brought in have pre-submitted their courses, and they've been approved for CEs and assigned. And those that we attend, and our badges are scanned when we walk in the room to say that we've attended it. And so, and then we're given a report later, they're actually online now, showing how many CEs we attended while we were at that meeting. And so that's why I'm saying now, since they're recorded while they're going on, if somebody pays to take that course after the fact, they're monitoring who pays to take it. They're monitoring who signs on and clicks on. What I don't know is if they can monitor if you stay on for the full hour presentation or not. But you know, when I think about that, if I attend one live, I can scan and walk in, attend half of it and walk out, and I don't get docked for it. So I guess that's the same level monitoring for an online participation as an in-person presentation. But when we go to these meetings, David, we can earn up to 30 plus CEs over a 3 or 4 day time period if we choose to attend that many.
I was just curious how that works. So I know in my profession, when we do an online class, then I think you were mentioning a self-assessment or a post-test, they call it, make sure that we actually viewed the material and understood it. So I don't know that those classes, when they put them online, if they could add a self-assessment at the end of it. Or like you said, just knowing that you attended the class is enough. That's all I was getting at.
Okay. Yeah, those do not have those assessments, but I can tell you there's another thing that we can choose to do, and that's to review a clinical article that's published. And we read that article, and then we do take a quiz and turn that in, and you have to pass the quiz at a certain level to get CE credits for it. So there are some of the things that we take that do have the post-test or assessment, but these conferences do not. So let me ask this, Chris, if we could, can you put the language up that we're talking about maybe at the end with that Word document, or right now? Can we see the language specifically before we agree to that change?
So this is Alex Phipps, Assistant General Counsel. I can share my screen right now with the edits that I've made. I want to make one point while I am sharing this document. The language that we're editing here is specifically for the live portion of the requirements, which is 50% of the total hours. So currently, the status quo is that they must be live instructor-directed activities. We're not discussing the categories about, reviewing an article or other, self-study activities. So I think that's an important thing to keep in mind, that this change is specifically targeted towards the live instructor-directed activity requirement. But as you can see, and you should have that visible for your shared screen now, the red edit is what I've just deleted. The underlined language is the new language that we had proposed in your packet. So if everyone could see that, that's the edit that I was doing while we were talking about it.
Okay, so let me ask Mark and Randy, in reading that, would you interpret that if you paid for AOPA or Academy to see it after the fact, would you consider yourself covered in that 50%? Yes, Mark.
Mark Kirchner, I just reading it like this, I don't think it's clear enough, because you could, I didn't go to the AOPA one that was after the fact, but the way I'm hearing from you, Catherine, is it was posted, you could watch it. So if there's no way to know if you watched the whole thing, you could log on to it and then get off, and then I could turn that in as CEUs. I think that's not what we're looking for. Some of the other ones you mentioned, like a prosthetic company that would offer a foot and do a CEU that's pre-recorded, you go through and you have a time frame that you have to follow through. If you click off, then you have to go back to the beginning. So it's not like I can click it on, I can go see patients, then come back and take the test. So there is an avenue there where it is self-assessment, but it is also monitored so that somebody can't cheat their way through the system. I just,
You got any ideas on how we could word this? I think we're going to get some pushback if we tell our professionals that if they attend AOPA after the fact and they pay, I don't remember what they paid, $300 or something to be able to take that after the fact, but it's not going to count towards Texas CEs.
I agree.
And to see. And I do think that this needs to be, I've had several questions thrown at me about how this was going to be handled with our new technology. So I am concerned that we do need to address this. Yes, Mark.
Mark Kirchner. So Alex, I haven't reviewed what the CEU requirements are. So underneath our CEU requirements for orthotics and prosthetics, and I'm assuming that the way this is worded and just reading this is 50% can go through continuation requirements that are live, and then 50% can be done self-assessment, or is it calculated out to where X amount have to be here, or it can all be together? Can you explain that to me?
Sure. So subsection F of this section says at least 50% of the total hours of continuing education required must be live instructor-directed activities. 50% or less may be self-directed study. So it does allow up to 50% from both categories. It doesn't specifically list an hour requirement or anything like that.
Catherine, Mark Kirchner. So
Yes.
really cleaning this up is you're just really offering, because of what's happened with COVID, the language is being proposed so that if there is other telecommunication that has live interaction, it would be accepted as instructor directed activities from the first part of F.
Yeah, that's
Am I
correct. We
understanding
were
that
trying to
correctly?
clarify that to make sure any question about, having a remote teleconference as opposed to you being in person in a seat in the auditorium.
This is David Gonzalez with TDLR. Let me offer something because this is challenging with technology and all the different ways that we can go about it. If Alex were to take out the words instantaneous or just the word instantaneous, but leave the rest of it, that would allow for two-way interaction at a later date or a later time. Does that solve some of the issue about concerns on whether or not there's going to be a requirement for communication and interaction from the live instructor that wouldn't be live at that time, but it permits two-way interaction? And I think you brought that up earlier, Ms. Mize, that there is allowance for responding to the questions afterwards. There may not be a reassurance, there's a check or a quiz, but I think taking out just the word instantaneous gets us closer to what I think y'all are trying to achieve. Just my thoughts.
Okay, thank you. And that might be the case because when you do watch the recorded session after the fact, it does put up the information of the speaker that was instructing the course and how to get in touch with them and how to ask them questions. So there is an avenue there to reach out to them if you want to. I mean, Mark, David, Randy, tell me if you disagree, but I think we ought to be able to count this towards this 50%, or I think we're going to be in trouble in gaining this 50% of our CE requirement. Yes, Mark.
So Mark Kirchner, so I would be better at this right here, saying that we can go back to AOPA and Academy as clinicians to say, because of everything that's going on in life today, is there a way that they can do some interaction after like an online deal, after we do an on-site person 2 weeks later, to have some type of self-assessment test added to that, or be able to question the instructors that give those presentations with some type of return? I would go for that.
Okay, and I think AOPA and Academy would both be receptive to that request, because I think this is going to be a concern for all of our licensure states in trying to monitor how we're now going to get our CEs for all of those states. So whoever can certainly address that with those two organizations and with our state organization. So given that, with the wording that is now on the screen, do I have agreement that we could move forward by just removing instantaneous from each one of you guys? And Randy, yes.
Yeah, I'm good. I'm good with that language.
All
I think
right.
that takes care of it.
Okay, thank you. And I'm having to flip-flop to see everybody's picture, so sorry. So Mark, you're okay with this
Yes.
wording?
I'm good with that too.
And David, are you going to be okay with this wording?
This is David
Yes,
Gonzalez with
yes.
TDLR. I just want to make sure, don't forget, Ms. Mize, there will be a motion, so everybody will have a chance, and we'll take a roll call vote. But I really appreciate the work that's going on here, kind of like a work group.
Can I make a respectful, friendly addition to this, even though this is not a motion? Could I suggest that we add live or pre-recorded here, just to clarify, since it does sound like pre-recorded is the topic of concern. But of course, we can eliminate that if that's too broad. But it seems
Yeah.
that the framing of this whole issue has been the live course was pre-recorded, and now it's being offered, but we're looking for some way two-way communication after the fact as well. I feel like we do need to mention pre-recorded in this section if we're going to do that.
I appreciate that very much, Alex, because you just triggered another thought. When I went to AOPA, some of the presentations that I watched live and in person were actually pre-recorded by the speaker. So we would have a panel discussion, and 3 of the people would be pre-recorded, and then there would be 2 that were actually there in attendance. So it was a mix. So I think that's a great ad right there. Okay. Have we beat this dead horse enough? Yes. Yes, Randy says. Yes, Mark
This
says.
is David Aarons. I think with the wording you now have, I think as somebody, looking at it from outside, to me, that's pretty clear. I think as long as there's some kind of record that you attended, as you said earlier, even if you go to a live event, you could scan your badge, walk in for 5 minutes and walk back out, and you're still counted as having taken that course. So there's no more positive verification that you took a live course than if you watched the pre-recorded course. And then adding the two-way but not instantaneous communication allows for that feedback and being able to ask questions. So to me, that sounded like an appropriate change.
All right. Perfect. Thank you very much. So Alex, I'll give it back to you and let's keep going.
I have to apologize. I froze very briefly there, and I think the shared screen probably dropped off. But if anyone did have any comment in the second or two when I was closing that out, I apologize, and please let me know. But sounds like what I heard, we are good with the live or pre-recorded instructor-directed activities may be offered in person or using telecommunications or information technology that permits two-way interaction between the instructor and the attendee. Okay, all right, well, I'll move along, but again, feel free to bring up any other edits, and I apologize for that brief frozen moment there. Moving on, we just discussed 114.50, so now I'm going to move on to 114.75. That's scope and conditions of practice. And in this section, we add a reference to telehealth within the scope of the licensee authority as something that is an additional part of the scope of practice in a facility. Currently, that section already allows off-site practice. And that section includes that within the scope of practice within a facility. So we already have off-site practice, and we're adding off-site and telehealth. And there is a line edit to this section, which I will share here in just a few moments. But you know, if you do have any questions, let me know. And then I will move on to the last section, which is 114.80. The changes in 114.80 are to the fee schedule. And as I mentioned previously, we are getting rid of the fee for practitioner in charge or safety manager changing. So you will not need to pay a fee when those are changed anymore. And we'll also be eliminating the fees for renewal of a voluntary charity care license type. So for most of our health programs that require a voluntary charity care license type, the fee is very low or zero, and our fee is extremely high. So we wanted to align that with the rest of the department's voluntary charity care classifications. And just to remind everyone, that is a license type that only permits someone to work for a charity and not for profit. So it is not a situation where someone is generating a lot of income. They are seriously just volunteering their services. So we want to make sure that that is not a burden on them and to lower that fee as low as possible. So that is the summary of our changes. As I mentioned, we do have two more line edits that are in addition to the one we just did.
Before you continue, Alex, I want to recognize Mark with a question.
Okay.
Go ahead, Mark.
I'm sorry, Mark Kirchner. Alex, was there a reason why that there was a change to not charge for those fees? Is it to try to bring people into more compliance maybe? Was that the reasoning behind this?
Are you referring to voluntary charity care, or are you referring to the practitioner in charge?
Practitioner in charge and the safety manager.
So after staff's review of this, and we may have some people on the meeting that have more detail than I do, this change is basically a very straightforward ministerial change that the department does internally. I believe it's simply changing a person's name inside a database. So it doesn't cost the department anything really to perform this task. And we felt there was an unnecessary burden on individuals who had to, oh, I see Leonard has popped up, so he may have more detail than that. But effectively, it's just to lower the cost on our licensees because it wasn't a necessary charge. But Leonard, if you have something to add, please do.
Sure. This is Leonard Rivas with the licensing division. So just to give you an idea, it's not a huge workload for us. For FY21, we had 8 practitioner in charge changes and 4 safety manager changes. And so the department felt that the workload was not that overwhelming that we could reduce the cost and still allow individuals to make those changes.
Yes, Mark.
So the only thing I would bring up is I believe at the very beginning when licensure was around, I was back in the 90s, and we were part of this. And one of the reasons why that there was a request for practitioners in charge and safety managers is to make sure that the public had some type of way if there was a complaint on a facility. My concern is there's some facilities, a lot of people are moving around, and so if a patient did have a complaint to address to a licensed facility, and they go on the website and find a practitioner in charge, that practitioner has maybe moved on to 3 or 4 other facilities. So that would be my concern of, I believe there was a fee put in here to hold the facility owners accountable to make sure that they stayed in compliance with the proper on-site practitioner in charge and the safety manager.
And I'd like to follow that comment as well. My guess is the reason you didn't have very many changes submitted that you had to process is because most facilities don't ever give this a second thought. And they don't even remember or realize that they are supposed to submit this as a notification of change when, as Mark said, people move around in different jobs. So my guess is if you would have to actually go do an inspection and ask who that person was and see if they're still employed to see how many people are remembering to do it. But the vast majority of people that I speak to, this never crosses their mind. And I can tell you, when I was owning and running a facility, it was a, oh yeah, I'm supposed to kind of a thought. And it didn't stay current with me.
This is David Gonzalez with TDLR, and forgive me, we're actually talking about lowering fees to the public, which is something very popular typically with the public. But there is nothing that I'm aware of, and correct me if I'm wrong, staff, that would keep us from still making it a requirement that they notify us. And I'm not sure if it's a new edit or addition, or if it's something that's already there. Obviously, the fee does not have to coincide with whether or not you want to require it. That could be separated. So I just want to bring that to y'all's attention.
Okay, thank you, David. But I think Mark's point is by attaching a fee to it, you are creating maybe some more incentive. Steve?
The intent is to create an incentive to do it by eliminating a fee, because fees have to be processed. And if you just want to change your practitioner, you can notify us and you've changed your practitioner. It's just, it's simplifying the process. It's not eliminating the requirement. If anything, it should possibly improve compliance. I mean, that's the intent, to make it easier.
Mark?
It's $25 that takes us probably $50 to process.
I agree. I like reducing fees. It's great for everyone. I thought part of the intent was in the rules, and when the law came around, it was to hold people in compliance. And just because that nobody is doing this doesn't mean that I see it from a different avenue, where underneath what Leonard was saying is not enough changes were made is a good reason to get rid of this. It's really, the intent of the law was about patient care and holding facilities accountable to hold their clinicians and staff accountable, and for the protection of the community. So I just wanted to get clarification on why it came about, but I'm good either way.
Can I jump back in again and add a little extra detail just to add some nuance here? When we calculate what fees are based upon, we look at the cost to the department to actually, perform this task, or what we need to collect based on the legislature's, directives to us. We don't use the fee part of this as a cudgel or an enforcement action, because we do have an enforcement category, and failure to notify the department of a change in the accredited facility designation for the on-site practitioner or for the safety manager is a Class A violation, and the penalty for that is between $50 and $1,000. So we would impose a penalty on someone if they failed to do it, and that could be far in excess of the fee that would be assessed just for changing this. That's sort of the way that we look at it at TDLR. We're going to come after someone and actually give them a disciplinary action if they fail to do it, instead of expecting to just pay a small amount on the front end that we don't actually need to collect.
I'm sorry, I'm back and I got thrown off the meeting. Alex, did you answer the question, or do I still need to help with the question? Or sorry.
I don't know that I necessarily have answered it completely, but I did add a little detail there, and I'm happy to add any more if any members have any questions.
So Leonard, what Alex told us, he pointed out the fact that if you do not notify TDLR of the change, that then falls into a Class A action that can be taken against them, and the fee for being slapped with a Class A action is much higher than the current fee we have to process a change. And so I think that's actually quite relevant. And does that satisfy where you were headed, Mark?
Yeah, that's fine with me. I was just curious of why it was changed, because I remember what the intent was at the very beginning.
Okay.
Thank you. Thank you for clarification.
All right, thanks,
Sure.
Alex. Again, I'm sorry I got cut off the meeting. Sorry.
It's all right. So yeah, so I think that's a good answer, Alex. And if Steve is right and we can get better participation by getting rid of the fee, so people will do the notification, and then if they don't, we'll slap them with a fine after the fact. I assume that which is a dangerous thing to do, but I assume that that's one of the things that is easily and readily checked when we do facility inspections. I hope it is. And actually, I'm wondering because I think you would have more violations there if it were checked regularly. So we probably, whoever does facility inspections, that we need to make sure that that's one of the items that's addressed.
Leonard Rivas, Licensing Division. So
Yes.
we do on occasion, we'll get an email from an inspector and say, hey, is Catherine Mize the practitioner in charge of this facility? Or is David Gonzalez the safety manager? So we do get emails, not often, but on occasion from our field inspections asking who the safety manager or the practitioner in charge is of a certain facility.
So if you're occasionally getting that question, does that mean they're checking it or not
They,
on a regular basis?
I would say that they are checking it if when they're doing inspections on the facility. And there's Juan Munoz from field operations.
Yes, yes, ma'am. We do check that. As a matter of fact, I got a question from an inspector just now to confirm some information for LPS location he was just at. So that is part of our daily check, our periodic inspection process. So we do ask for that. We actually confirm that prior to going out into the field or try to identify who those individuals might be. And then when we get to the facility, we confirm whether that individual is still there. And if they haven't, then we have a process where we give them the information so that they can go through the process of making the change through TDLR.
Okay, thank you very much.
Yes, ma'am.
So Alex, I think we throw it back to you and you were going to put up some line items on some other changes.
Yeah, and just as a reset of where we are, board members, we've walked through the short summaries of all the sections. So what I'm going to present to you now are 2 edits to the language you have in your packet. So we sent that language in the packets out a few weeks before the meeting. After that, we did have 2 additional changes that arose from the work groups. So we want to show you the edits that staff is recommending here today. And this, again, is edits to the language that you have in your so I'm going to share that right now, and then we'll walk through that. So I hope everyone can see that. So what I've got here are 2 different edits. The first one is to 114.27, and that's the assistant license section that we talked about earlier. So as you can see, the language in your proposed rule package is effectively what was already in this section pre-September 1st of 2018. The change that we're looking at here is in subsection C, and this is C4. So what we're going to add is the highlighted language after prosthetist/orthotist. And so we are adding a comma and then saying, or a licensed orthotist for orthotic care, or a licensed prosthetist for prosthetic care. And so this is a clarifying change to make it clear that a licensed prosthetist orthotist assistant can be supervised by any of these individuals as appropriate based upon their classification. As I mentioned, this is a request from the work groups. I believe, Ms. Mize, this is your requested language. If you do have anything additional you'd like to add on that, feel free to, or if anyone has any questions, let me know.
Yeah, I'm good with that. Anybody
Okay.
else? I can't see everybody's faces. Let me check real quick. Any other questions, Randy or David? Nope.
Okay, I'm going to move on to the next section, but of course, if you have a question, let me know. Moving to 114.75, this is scope and conditions of practice. We're looking at subsection F here, and this is a requirement for practice settings. As I mentioned, we have an addition here, and this is the addition that we're having from the packet, which is and telehealth. The recommended change we have to the language in your packet in subsection F3 is to add the highlighted language here within the licensee's scope of practice, and to get rid of the and registrants, since that is redundant language. We no longer have any registrants in this chapter, so it's not necessary here. We're just making this a little more clear that the practice is only within the scope of the licensee's ability to practice, and we're eliminating registrants, which is not necessary. Anyone have any questions about that? Or Ms. Mize, if you'd like to add any additional comments, let me know.
Yeah, hang on just a second. I gotta find my notes on this one. That's something else. You put in. Okay, so that was the suggestion that I was hoping for. My only other comment that I have is the use of the phrase "and registrants" that you did strike here. That is used over and over again throughout our rules. It's not in just this one location. So is it appropriate to take this opportunity to strike that every time it occurs throughout the rules?
It is a project that we have been slowly doing. As these sections are open, we have been slowly pairing off and registrants. The reason why we didn't do that in this package is because it would involve pretty much every rule section that we have. Our goal is to do that slowly when these sections are open for other substantive changes, just as a workload concept, because each one of these sections that has to be amended is a large amount of work, one for the department, and it's also a large amount of text that has to be posted on the Secretary of State's website and be open for comment. So it was sort of a choose your battle choice to not get rid of registrant in every location. So as I'm sure the advisory board members know, registrants have been eliminated for several years now. There was a clarifying change we made back in January of 2020 that altered the definition to remove the reference to registrant as well. So since that phrase is not really a problematic phrase in most of the locations that it's currently existing, we did not go through the entire chapter with a fine-tooth comb trying to rewrite every section. Effectively, we could do that. If you'd like for us to do that, this package will have to be massively expanded. And so we will not be able to go forward today.
Okay, yeah, I think that's fine. Let me ask a question of our advisory board members on this section in particular. I want to be sure that each of you reads this and understands where we're going with this, because with telehealth coming into play like it has during the pandemic, I want to be sure that it is clear to the reader of this rule that if you're an assistant providing care to patients, that telehealth doesn't give you the ability to go out and see a patient, provide a critical care event. So let's say fitting a prosthesis as an assistant in someone's home. If you have the, how do I word this? If you have the practitioner online with you. So the situation that I'm sort of trying to lay out here is a facility could potentially have one prosthetist sitting at a desk, and he could have 5 assistants, or she could have 5 assistants, running out and seeing patients all over the place. And because they do a live link, screen share, whatever, however you want to do it, that would count and that would be okay as a supervised event. So this is why I really want us to pay attention to this in particular, because I want to prevent that from happening. And I can't see everybody's faces at the exact same time, so.
I can stop sharing my screen if that'd be useful.
Well, no, leave it up if you don't mind, Alex. I think it'll help us dice words with it in front of us. So Mark, go ahead.
So I just give me a few minutes. I want to do a little review, so maybe I might have a question.
Okay, perfect. Randy or David, do you have any thoughts, or do you want to think about it for a second?
Randy Duncan, I'm not sure with that as the proposed intention. which I agree with, by the way. I'm not sure that that's clear in the language as stated. Was that the main reason for the addition of within the licensee scope of practice? Is that technically supposed to retro refer back to the fact that as an assistant, you cannot participate in critical care events without the on-site direction of a licensed practitioner?
Correct. That's what I'm trying to prevent. Now, when you look at critical care events, it does say that it requires the physical presence of your supervising practitioner. So I literally want physical presence. I want the practitioner there doing the fitting. I don't want them on a video screen watching the assistant doing the fitting. And so if we are comfortable that relying back on that definition is enough, great. If not, we could somehow figure out how to work in the word physical presence or something to make that more clear here. Because what somebody's going to do is read this and they're not going to necessarily go back to the definitions of critical care events to see the physical presence wording.
I might interject here as well. This interacts with another section that we're amending today, which highlights why this amendment is important. If you go back to the 114.27 assistant license section in subsection C,
Yes.
the language about being physically present is also there in that subsection for the scope of practice for an assistant. So I'm looking at C6, and it says a licensed assistant may only assist in the performance of critical care events while in the physical presence of the supervising practitioner. We have a concept that, in the legal world where the specific is going to overrule the general. So if anyone was to try and argue that being able to practice telehealth would allow them to perform something, this specific provision that outlines the exact scope of practice for the assistant is going to prevail over the concept of being able to do that by telehealth. There's no real way you could interpret physical presence of the supervising practitioner to allow them to be supervising remotely.
So thank you. And I agree with you. My only issue is if somebody reads this sentence, can we maybe here direct them back to looking at the defined scope of practice for anybody's role? I guess what I'm after is I want to stop the activity before it starts to happen. If somebody reads these rules and they don't read them well and they just read this and they go, oh, we can do this. They start doing it. Now we have to catch them in the act, and then we have to bring a complaint against them. We got to go through the whole process. So I just want to make it crystal clear, because I know that this is something that has been questioned.
I'd
So is there
respectfully
anybody?
suggest, oh, I'm sorry, I didn't mean to speak over you there.
No, that's fine. I was going to ask you, is there a way to refer in this number 3 right here and remind people to look at what the defined scope of practice is for a particular licensee?
I don't know that that's necessarily what we should do in the rule section. I was going to suggest actually the best way to go about that is outreach through our website and through FAQs and other relevant sections about how we present the abilities of the assistants, the abilities of the practitioners, and the abilities to utilize telehealth. And those are things that we've tried to build out on our website and will continue to do as we implement more of these rule changes and bills. But if we're trying to refer back to every single section in this, I think within the licensee scope of practice does actually do that. And adding the direct citations in this section really just sets us up for a little even more confusion if there's a procedure or a situation that isn't specifically outlined in one of those scope of practice rules. We may generate more confusion than we're solving just by saying, look, as long as it falls in these categories, you can do telehealth or you cannot do telehealth. I think we're being a little too prescriptive, trying to list out every section that may apply in this section just with the interest of avoiding confusion.
All right. Well, and for those that don't know me, I usually create confusion before I clear it up. So that's just sort of my modus operandi. Uh, uh, Mark, what do you think about, or any of the other board members, what do you think about clarifying telehealth and how we can operate in that space through an FAQ? Yes, Mark.
Sure. I like Alex's approach there. I think that this is, I mean, to me, it's clear. It's within your scope of practice. If the licensee is going to try to cheat that, Catherine, they're going to try to cheat it anyways, and we're going to have to go to them after enforcement. But if there's, I believe what Alex is proposing, if you put it under the questions on the website, it's kind of like we're going to lay it out and spell it again to you that this is exactly what it is. So at least if we do have to go after a licensee, they can't claim that, well, I didn't understand. It wasn't clear. I mean, if we give them all the tools, I think that's a good way to go.
Okay. Randy, do you and David have any thoughts on that? I can't see you. There you are.
You know, in my opinion, failure to read all the rules is not a acceptable reason to not follow the rule. Okay. You know, they should have read line 6 of F there of that other section and saying, well, I didn't read that part is not an excuse for violating, in my opinion. So to me, putting it in there again, you're building redundancy. FAQ is probably a more efficient way of doing it to me.
Okay. Randy, do you have any comments?
Randy Duncan, I was just trying to think if there was a way to include some language to clear it up a little bit, but I mean, it still does exist that, you know, those critical care events are to be provided for by the licensed practitioner. This does not give, you know, free license to an assistant to provide those while not under the on-site direction of but people are going to interpret things the way they interpret things. And, you know, this is something I believe is already happening. This is not something we're nipping in the bud. We may, I don't know if addressing it specifically in an FAQ on the website would provide enough documentation to say, hey, it was on there very specifically that that's not something that is made appropriate by including a telehealth provision in there to start allowing people to do this.
Okay. One of the reasons that I think it would be a good idea to put this in the FAQs is to help our customer service that are taking phone calls. Because if this is a question that's called in and a customer service rep doesn't know how to appropriately answer it, and it's maybe a little tricky to find in the rules here, if they could refer the caller to FAQs on how telehealth is to be administered in our program in Texas, I think that would be a very clean way for that direction and that answer to be given consistently. So if we don't have any objection to that, I would like to refer this to a refer wording for an FAQ to be created to one of our work groups.
I'd recommend bringing that up during the agenda items for work groups.
Okay.
So we're not creating any confusion about what agenda item we're on right now.
Okay, perfect. Now is that so I guess we're in agreement with this new wording here that you've done in yellow and you still have on the screen. And we'll Mark, yeah, that was a thumbs up. Or was that a Giga Maggie's? Was that a Giga Maggie's?
Thumbs up.
All right. I do have an answer to a previous question when we were discussing how our attendance is monitored if we take one of our programs after the fact, after it's been pre-recorded, like the AOPA or Academy. And the answer is that for AOPA in particular, that their platform records the exact time a video session is started, when we're taking it online after the fact, and ended by that individual. So it actually sounds like that there is better monitoring of somebody who's taking these classes online than in person. And so I guess my next question to AOPA is going to be, are we required to attend it for a certain portion of time so that it's counted towards our CEs? But at least we know they're monitoring when you turn it on and when you turn it off. So I think that is a good thing to know. And if AOPA does it, I'm assuming Academy does it. And if they don't, I will definitely ask them the question and bring it to their attention that they should do it and that our Texas Society should do it. So, all right. Alex, do you have anything else to add to these rules?
We have presented everything that's out there right now. If any advisory board members have any questions, let me know. If not, I would recommend a motion to propose the rules as presented here today. And I would specifically note the changes that we went through both, live there when we made the line edit to section 114.50, as well as the two sections we just discussed, 114.27 and 114.75. So staff would be looking for a motion to propose the rules as presented today if you don't have any further questions.
So, Mark, yes.
Make a motion to propose the rules that were discussed today. They were published and changed by Alex today.
Do I have a second to that motion?
Randy Duncan, second.
I believe that throws us into a roll call vote from Miss Anna.
Yes, ma'am. David Arends.
Aye.
Randall Duncan.
Aye.
Mark Kirchner.
Aye.
And presiding officer Catherine Mize.
Aye.
Motion passes, ma'am.
Thank you, advisory board members.
Thank you, Alex. All right, so now my desk is a mess. Hang on just a second. All right, next on our agenda is I, and letter I, not me. And it's our work group updates, appointments, and assignments. So we have 3 work group updates, and I'm going to present on 2 of those. The first one is standard of care. And so this is just a very quick update. It's kind of repetitive of what this work group did prior to this meeting. And so the standard of care work group reviewed the relevant standard of care draft sections via an email in mid-October. The group had the opportunity to comment and give suggestions to their part of the rule packet that was presented today. The group suggested some changes to some of the proposed language and terminology, and it was responded to appropriately by the department and then discussed today and accepted in a motion with those changes. So that was the standard of care. The next one is the licensing work group. And for this one, the licensing work group again reviewed the relevant licensing related draft sections via the email that was sent out in October. We had the opportunity to comment and give suggestions for the rule packet that was presented today. 2 members had questions and comments about the jurisprudence exam and the deletions related to the application processing, and those were discussed and answered by the program staff appropriately. The third one is the education and examination work group. And Randy, I believe you're giving that report.
Yes, ma'am. Education examination work group reviewed relevant draft rule sections via email. Had opportunity to comment, give suggestions. There were no changes recommended.
All right. So now, thank you very much, Randy. So what we can do now is we need to make some new assignments to the work groups. And I believe, Mark, your name is missing from any of these work groups. And so, I really want to be inclusive of everyone. So Is there a fourth work group, or do we just have these three, Anna?
We have 4 work groups. There's the enforcement, licensing, education and examination, and the standard of care work group.
Right.
If you see the document I'm sharing here, it shows all the active members that we have, as well as the staff that's assigned to it.
Okay. And personally speaking, I would like to see at least 3 of us on each one of these work groups so that when we do meet, hopefully all 3 of us will attend, but at the very least, we have a better shot of getting 2 people in attendance. First of all, let me ask this question. If you see your name on any of these 4 work groups and you would not like to be on one of these work groups, speak now or forever hold your peace. You good, Randy? David? Yes? Okay. So Mark, would you like to join the enforcement work group? We only have 2 people. Yes?
Yes.
All right. Consider yourself signed up. And we need a 3rd person on education and examination. So we can, let's see, David could jump on that one, or Mark, you could jump on that one too. I think everybody has at least 2.
You can put me on that one too.
All right, good boy. I assume that's you, Anna, typing. Thank you. And then we can also discuss, I think this is the right time to do this. Somebody correct me if it's not. Can we discuss new assignments for work groups at this point? Or do I need to go to the next agenda item?
No, this is a perfect time to do it. Thank you.
Okay. So the one thing that did come up during this is creating an FAQ for the telehealth definition of how we can perform telehealth and to stay within our scope of practices. And that would be referred to the, can you throw up those work groups again, Anna?
Of course, let me pull that up for you.
Well, it looks like she's having trouble, or at least, oh, there it is.
I had minimized it already, so I had to pull.
Okay, sorry about that.
That's okay. No, you're good.
Okay, so I think that that would fall under the standard of care work group. Is that correct?
Yes.
Yes. Okay. So we'll make that assignment to standard of care. So myself, Randy, and David, and then who would lead that with TDLR?
I will, Steve Eaker, TDLR.
Steve? Okay. So then, Steve, would you send out a poll for when we could meet to discuss this FAQ, or how do you want to proceed with that?
I can do that. I can send out a poll. We could draft an FAQ and send it out with the poll and then meet and discuss, and you could bring whatever suggestions you have to amend it.
I think that would be great. Do you want to draft that, or do you want me to draft it, or what do you want? How?
I can draft one and you can send me your thoughts at the same time.
Okay. All right. So we'll leave that in your capable hands. That's great. I might send you some thoughts. And so has anybody else seen a need for the any other things that we need to work on that need to be thrown to a work group? Is that a resounding no? David, I can't see your face on my screen.
David Arns, that's a no. I saw nothing else.
Okay. So I guess we're good for that. All right, well then I will move on to the next item. And that is item J, recommendations for agenda items for our next board meeting. Do any of our board members or members from TDLR have anything now that you want to include on the next board meeting? Which we're going to discuss, but just to go ahead and give you a heads up, we're going to be aiming probably for some time in January, perhaps. So if you have agenda items, anybody have an agenda item?
Presiding Officer Mize, we're going to have the public comments from the proposed rules that we're going to publish on the Texas Register for you. So that's
Okay.
going to be one item that we're going to put on the agenda for you.
Okay. And I have a question. If we think of an agenda item in November that one of us would like to have included on the agenda, how do we propose an agenda item and what is our timeline for doing that prior to the next meeting?
You can send it to me. We usually would like our agendas finalized 2 to 3 weeks before the meeting starts, just to get all of our materials ready. But yes, send it to me or send it to the advisory board, advisory.boards as TDLR email. You can do that.
Okay. So you guys, if you think of something, Mark, Randy, David, that needs to be discussed on the next meeting, please bring it to Anna's attention so that we can get it put on the agenda. Next item, K, we're almost to the end. This is very exciting. Discussion, date and time of the next board meeting. So Anna, you will send out a poll on when we can have the next board meeting, and that's also going to be somewhat dependent on getting the rules published and having the 30-day time period.
Yes, I'll get with our general counsel division and they will give me a timeline of when they're going to get the public comments back, how long it's going to take for them to compile them, and I will poll y'all for the next meeting.
Do you have any idea of when they will get published?
I do not. Alex may have an idea. Are you still on, Alex?
Yeah, it really depends on the workload of our legal division and how much time it will take for us to reformat them and get them published, probably in the next couple of weeks. But the Texas Register's publication format is a little unique. You submit it for publication, and then it could be up to 14 days until it's published in the Texas Register. At that point, then it's 30 days after the publication in the Register when the comment period closes, and then we do have some time after the comment period closes when we have to collect those comments, review them, and prepare our responses. So normally you're looking at, you know, a month or two at least until all of that is resolved.
And Alex, I have a quick question. When rules are published, is there any kind of a notification, I simply don't remember, that goes out to the public to state that the rules have been published? Or do you have
Yes.
to click on our page to know that?
We send out emails to the whatever program is relevant for the rulemaking. So if it's the Orthotists and Prosthetists program, if you're subscribed to the email list for this program, you will receive a notification. We prepare those in the GC division, and there's a short summary of what the rulemaking is, along with the link to review the rules on our page. Also, if you are subscribed to updates on the Secretary of State's website, you'll see when a TDLR rulemaking is made. And of course, it's also published in the Texas Register, although not many people receive the print version of the Texas Register these days. It is available online, so people do find it that way as well.
Okay, thank you very much for that information. Have I forgotten anything?
No, ma'am.
All right, well, I didn't announce Mark as our newest member on the advisory board at the beginning of the meeting, but Mark, thank you very much for signing up. Applause from David, applause from David.
Welcome, Mark and sucker.
Very good.
It's not that bad. This shouldn't be that hard. Just stay away from Catherine.
Late.
Good advice. Good advice. All right. So David Gonzalez, thank you very much for your leadership and all your information here. And tell Brian Francis good luck with his 39 programs. And,
David Gonzalez, TDR. I was going to tell you the same thing, Catherine. It's nice to see a seasoned presiding officer and definitely the participation. Randy, you're not doing the recruiting for us good for these advisory boards if you call him a sucker now. we need some help here. But definitely can't do without your help. The discussion today was great, and this is how boards are supposed to work. Even with the small technical difficulties, everything went through fine. So thank you for your leadership, Catherine.
Yep, no problem. I look forward to our next meeting, and we will hear from Anna on that scheduling. And so with that, I think I go to item L, which is adjournment. And I will call this meeting officially adjourned at 12:47 p.m. So thanks to everyone involved.